What do you do when your family member dies without a will?
Welcome to Gavels Down, Voices Up, where we flip the script on conventional legal discussions. I'm Rachel King, here to guide you through the murky waters of estate conflicts, inheritance disputes, and all of the dramas. We're not just talking about law, we're talking about how it affects your life, your rights, your future, and your money. From the courtroom to your living room, we bring you insights that matter. Dive into each episode ready to challenge, learn, and grow. Ready to change the dialogue. Let's begin. Gavels down, voices up.
My name's Rachel King. I am a board certified specialist in probate in California, and we're going to talk all about what this looks like and what you can expect. Today, we're going to discuss the ins and outs of what happens to somebody, whether that's your spouse, your children, your family member, your friends, die without a will. By the end of this episode, you should have a complete understanding of the legal process, some tips on what you can do, and generally how long it takes and what you can expect. But don't worry, I'm not going to go on forever because, quite frankly, the law is boring. So we're going to keep this short, simple, but get you the information that you need. So yesterday, I got a phone call from a man that said that his dad had recently passed away and that he wanted to know if his dad had a will. Here's the thing. I know, I'm going to tell you, there's no magic portal or any magic wand that attorneys have to see whether somebody actually had a will or did one. In fact, a will can be as simple as some chicken scratch on a cocktail napkin or a very formal estate plan. In any case, they're private, and if we can't find one, then the law presumes that it was intentionally destroyed and we're left with somebody who passed away without a will. So now let's get into what I told him. I once learned that the death of a family member is arguably one of the most stressful things that you will ever have to go through, like in the top 5. So you're not alone. Why is it stressful? One, you are dealing with the grief and mourning process of somebody that you loved, which in itself can be all consuming. Throw on a legal battle, which also can be completely consuming, and you are left with like the perfect storm. Toss in or sprinkle in some family relationships and the family drama and all of the people that come out of the woodwork for money, and it can be truly a nightmare. But it's okay. You're going to be okay, especially at the end when you figure out what you have to do and how to get there. So, when somebody passes away, the first thing I always recommend is that we get into their house, somebody. Go into their house and look around. Maybe you'll find a will. Maybe you'll find an estate plan. Or maybe you'll find some kind of tip that will lead you to determining whether there is a will or isn't a will, like the name of an attorney or some document that suggests that maybe there was an attempt to create a will. Then you can go follow those breadcrumbs and see. If there's a will, great, then we have a will. And if there's no will or you can't find one, then we move on to the next step. So if there's no will, then we have the California Probate Code. And the California Probate Code is essentially a huge set of laws that handle everything that happens when somebody passes away without a will. It, of course, obviously also handles with a will and while you're alive and incapacitated. But for today, we're going to focus on the California Probate Code when somebody dies without a will. I will add in a little caveat that even if you go through this process without a will and later you find one, there are things that can be done to get that will admitted. But again, today we're going to say no will. So in California, under the California Probate Code, we have intestate succession. That's a super fancy word that basically means we have laws that determine who's going to be in charge and who's going to inherit. There's also preset laws as to who gets paid what first, like order of priority. And so when somebody doesn't have a will, we rely entirely on the laws because, like, what else is there? So if you're married and you pass away without a will, then your spouse is like the highest priority level to be in charge, like to be the executor. And your spouse also inherits. If you have children, your children will inherit sometimes. So if you don't have a spouse, then your children take priority to be in charge. And if you have multiple children, all of them end up having the same priority. And then it's like, who wants to do it? Or unfortunately, if they all want to do it and they're not getting along, then it's up to the courts to decide who is going to be best suited to be the executor. Oftentimes, the court will say, we're going to scrap all of you and put a professional in. But the first thing that we look at is who's going to be in charge. Again, level of priority is spouse first, children, and then we kind of just keep going. If there's no children, then we look at grandchildren, then we look at parents and siblings, and we really just find somebody who is able and willing to serve. And if we can't, fear not, the government has come in and we have the Office of the Public Administrator, and that is a government agency that will take over an estate plan. But we try not to rely on that, right? Especially in 2025 or, whenever you're listening to this, it's really quite easy to find somebody in the bloodline, a whole lot easier than it was like before the internet. So then we move on to who inherits. Under intestate succession in California, we're a community property state. So we're going to look at whether property is separate property prior to marriage or inheritance during the marriage, or it's community assets and property that was acquired during the marriage, because that matters. When there's no will, it matters what kind of property we're dealing with. If it's separate property and we have spouse and children, then they're going to share. There's a formula and like fractions. And if you really want to know, if there's a spouse and one child, the spouse is going to get 50%, the child is going to get 50%. If there's one spouse and multiple children, the spouse is going to get 1/3 of the separate property, and the children will share equally in the remaining 2/3. That's for separate property. Community property, a whole nother ballgame. Actually, spouses are like entitled in most cases to get the community property when there's no will. So it really matters, even if there's kids. If there's no spouse and we go to children, if there's no children, then again, we just keep going down this bloodline until we find somebody that can inherit. But what happens when you have 3 children, you die without a will, and one of your children has died as well? In a will, you can do whatever you want. But when we're talking about intestate succession, like we are today, no will, then your children would inherit equally. So your property would be divided equally between your 3 children. The one that passed away, we're going to take that 1/3 share and we're going to leave it to that child's heirs, right? We're going to go down the bloodline. So maybe grandchildren inherit. So it's not automatic that if you have 3 children and one passes away, the other 2 are going to inherit equally. We go down and we allocate accordingly. This can be complicated. Don't worry. What I tell people is just start with a family tree. Put your family member that passed away in the middle and then branch out so that we get at least 2 levels of living people. What is a level? Like a child and a grandchild would be 2 different levels. A parent and a grandparent would be 2 different levels. A parent and down to siblings, we go up to parent, down to siblings, 2 levels. So put together your family tree. Then we can figure out who not only inherits and can be in charge, but it also helps assist down the road with notice issues, like who's going to be served with process. That's for later or maybe even another video. Now for a quick break. This episode of Gavels Down, Voices Up is proudly brought to you by King Law Firm Attorneys at Law Incorporated. We're not just about winning cases, we're about making a difference. Whether it's probate litigation, conservatorships, guardianships, trust disputes, or standing up against elder abuse, we bring you excellence, experience, and empathy to the courtroom. At King Law Firm, we're more than lawyers. We're your team, in your corner, advocating for your rights and making your voice heard. Visit us at The Lawyer King and on the socials at The Lawyer King to see how we fight for you, with you. King Law Firm, Attorneys at Law Incorporated, where your fight becomes our fight.
Now let's get back to today's episode.
So once we know who's going to have the right to be in charge and potentially who is going to inherit and be entitled to notice, then we start the court process and paperwork. It can be really helpful to have an attorney help with this because while there's a whole bunch of forms in California, it is probably one of the most technical areas in the law. And if you do it yourself, hopefully you'll be able to. There's self-help clinics, there's courthouses, there's lots of resources for you to help. But if you don't, it can be delay after delay after delay, and it can be quite frustrating because when you're in court, the judge can't give you legal advice. So as you're preparing to file your paperwork for probate where there is no will, reach out to an attorney. See if you are interested in hiring them because probate fees are set by law. No attorney is getting paid until the court signs off on it. So you might as well go and talk to an attorney to see if you can get one to help you. Hands down, it will reduce your stress more than anything else. Why? Because you'll know what's going on. You'll have your questions answered, and you'll have somebody else that can pick up the stress and the load so that you know your case is being handled correctly and you have the freedom to go and mourn the loss of your family member. And quite frankly, being able to grieve can be the most beneficial thing to help you get through the legal proceeding. There's like nothing worse for the court, for family relationships than getting all convoluted, not grieving properly, and having your probate blow up. Once the paperwork is done, basically we file it with the court. There are some filing fees. We serve people, like I had discussed earlier, that are entitled to notice by law. There's a court hearing. At the court hearing, if everything is ready and it's all done correctly, then the court will sign off on the order, giving you or whoever is the named executor the power to go out and do their job. And so what is your job? Essentially, your job is to go and figure out what your family member owned when they passed away, what debts they had to pay, and to handle all of that, liquidate the house, collect the tangible personal property, give it to who needs to go, and get it all done and report back to the court. The court's going to require an accounting. The court's going to require receipts that say that, Aunt Sally actually got the ring. And the court is going to be making sure that you do everything. In order to make sure that you do everything, oftentimes the court will order that you post bond or that the executor posts bond. This can be kind of difficult because you got to be approved and that requires credit. You can definitely talk to a bond company about that or your attorney, but it protects the beneficiaries. So if you're a beneficiary, you might be interested in having the executor post a bond. That way, if they take off to Miami or to Costa Rica or something and spend all of the money, you have recourse. At the end of it, whether your probate takes 4 months, I don't know that I've ever seen one in California that takes 4 months because there's noticing that it requires longer than that, or 3 years. The process of probate is collecting all of your family members' assets, making sure that all required debts get paid. That includes taxes, and then giving anything remaining to the entitled beneficiaries and reporting back to the court and saying, I did all of it. You can get paid for this. This is not a job that you have to do for free. And in fact, there's laws under the California Probate Code that say that you are entitled to get paid for it. I've never understood people that thought, oh, this is such an honor. It's a pain. It is a pain in the butt. So if you are the named executor, if you are going to be the administrator because there's no will, pat yourself on the back. Know that you're doing a really great job. It's really hard and it's a lot of work. And actually, you deserve to get paid. Your pay will be court approved, though, just like us attorneys. So as you get through this process, you're going to have to marshal assets. Again, you have to figure out what is owned. Are there bank accounts? Is there real estate? Are there brokerage accounts? Is there life insurance? What have you found? I always say put together a spreadsheet, what it is, where the debts are, collect the mail, forward the mail, and keep yourself organized. Again, if you have an attorney, this can be super helpful. Then we can figure out what assets need to be handled through the probate and what can be handled outside. For example, a life insurance policy that has a beneficiary on it isn't going to need to go through probate, but we want to know about it because your family member paid for it. So let's at least make sure that all of this stuff is handled. The bottom line is that there's a lot of things to do, and staying organized can be very helpful. I definitely recommend talking to an attorney, and I know I'm biased, but if you can hire one, hire one. We are helpful. I have the best packet that will help you stay organized as you work as the administrator or the executor of the estate. So if you're interested in that, pop on over to my website, thelawyerking.com, and see what it's all about. Get the tools, get the information. You're going to be okay. So remember, If you have a family member that has passed away, first go and take a look. See if you can find a will. If you can't find a will, fear not. It's going to be all right. Figure out who's going to be in charge and have that person start the process, whether that's through hiring an attorney or going to the court. You're going to be filling out all of the paperwork for what's called intestate succession with the probate court. And ultimately, you're going to get the authority to collect the assets, pay the debts, and distribute to beneficiaries. If you have any questions, go ahead and reach out to me, thelawyerking.com, and I'm happy to do my best. You are not alone. There is so many resources out there that can help get you through this process. It's going to be okay, one step at a time, so that we can navigate through and get you from the beginning to the end as stress-free and quickly as possible. And next week on Gavels Down, Voices Up, we're going to be talking all about conservatorships. So like, subscribe, and follow so that you get to hear it first.
That wraps up another episode of Gavels Down, Voices Up. If you found value in our discussion today, please subscribe, leave a review, and share with someone who needs these insights. Your engagement helps us grow and impact more lives. I'm Rachel King, thanking you for listening and reminding you to speak up, because every voice deserves to be heard.